Thank you so much for joining us. Thank you to my panelists. My name is Anjelica Hendricks. I'm a fellow here at the Quattrone Center. Thank you so much, John, for that introduction. A lot of my research centers on the intersection between policing, misconduct, and race in the law, which unfortunately is a very, very large intersection. And most recently, just piggybacking off of the work of the last panel, I have some upcoming research entitled Tolling Justice, where I reveal that a lot of the police misconduct that we're discussing is actually more precisely policing crimes, where the victims of those crimes are over largely African American and other Black and brown individuals. So thank you so much to my panelists for attending today. If I could have a brief moment to introduce them. I'm joined by, to my far left, Professor Bennett Capers, who is the John Farrick Research Professor of Law at Fordham Law School, where he teaches evidence, criminal law, and criminal procedure. And he is also the director of the Center on Race, Law, and Justice. Thank you so much for coming. And to my closer left, I'm joined by the Deputy Assistant Attorney General for the Department of Justice for the Civil Rights Division, Johnathan Smith. He comes to this work as formerly an attorney with the NAACP Legal Defense and Education Fund, as well as a senior counsel previously at the DOJ Civil Rights, and also a legal director of the Muslim Advocate. So thank you so much, you two, for joining us. As we were listening to some of the last couple of days of conversations for this symposium, one thing that really stood out was really the critical failures of racial justice throughout the system. So, the symposium has discussed innovations in criminal justice, and critical to that conversation is the importance of racial justice. What does racial justice require is a question I'm going to ask my panelists. It's not a loaded question. It's just, what does racial justice require, and how does law enforcement agencies, police, I know a couple of individuals here in this audience are prosecutors, so how could they strive toward racial justice within their work?
Who do you want to go first?
You were the first one talking, so.
Oh, okay. So I'm comfortable with that. So I'm going to suggest three things, and it's three things that you can apply to anything. So I'm going to call those three things looking backwards and looking around and looking forward. So looking backwards is sort of acknowledging that race has always been entangled in how we police and what we police. Even thinking to the session right before this, even when you look at who's getting exonerated and who's being wrongfully convicted, you see how race is entangled with all of that. But part of looking backwards is also sort of acknowledging sort of a history that goes back much longer, much deeper. When we think, just to use a few examples, like rape, which is a subject I write a lot about, in this country, rape law often depended on the race of the victim and the race of the perpetrator. Like literally jurisdictions apply different punishments depending on that rape. Literally prosecutors had to prove, for example, that the victim was white in order to get the maximum punishment. There was actually different levels of punishment. And we see carryovers of that today. We could think about vagrancy or loitering that, really has its, really comes to fruition in this country around the time of the end of Reconstruction, when states really wanted to try to recreate slavery by a different name, by finding ways to arrest people and put them on work gangs. So that's looking backwards. Looking around is just thinking about okay, how does that history impact what we're doing now? To what extent are prosecutors, when they prosecute crimes or think about what things are even criminal, how much of that is a carryover from a racialized history? To what extent, for example, are we participating, prosecutors, in criminalizing poverty or criminalizing race? To what extent is law and order really about enforcing particular laws to maintain a particular kind of order? And then looking forward is just thinking about ways to change things. Like, we should think about equality, not just in what we police and what we prosecute, but also what we even define as criminal. So I'll just leave it there.
That's really great. And just the piggyback of what you're saying, there's a lot of research coming out now about how prosecutors and other law enforcement agencies use what's now called as dead crimes. were
Yes.
crimes that there are not many people being prosecuted for them, but there's a racial justice issue there. Things such as spitting on the sidewalk and other types of offenses like that. And Johnathan, if I could get your input on this question.
Well, first, thank you so much for having for me at the panel. And I know that you were joined earlier this week by Assistant Attorney General Polite from our criminal division, and I understand he left very big shoes to fill from the DOJ side. So I will do my best from the Civil Rights Division. I think in thinking about racial justice in the criminal justice system from the work that we do at the Civil Rights Division, I guess I'll answer that in two ways, one personal and then one kind of talking about the work that we do kind of each day in the division. So this is my second tour of duty, as you alluded to, in the Civil Rights Division. The first time I joined was in October of 2014, shortly after Michael Brown had been killed in Ferguson. And, I think, that led to this really national conversation about race and policing and how do we ensure that there is both accountability in law enforcement as well as abilities for communities and individuals and victims to meaningfully engage with systems that have such meaningful impacts on their lives. And then I joined again in July, the summer of 2021, shortly after the George Floyd killing and Breonna Taylor, the kind of national and international protests that we saw, and very much, unfortunately, the same conversations happening again, and the sense of frustration, rightfully, from communities that, felt unheard and, their concerns unaddressed by our criminal justice system. And that's why I think it's critically important that the work that we do in the Civil Rights Division is part of this conversation, because the work that we do each and every day is to enforce our federal civil rights laws. And many of those laws, the vast majority of the laws that we enforce, deal with this issue of discrimination and racial discrimination and how we can use those laws across all systems, but as relevant to this conversation, how we can use them in the context of law enforcement, policing, courts, corrections, what have you. And so, we use a number of different tools in our kind of day-to-day work, which I, will talk about really briefly, but happy to, talk about in more detail as appropriate. So the first is on the criminal side. So in the Civil Rights Division, a lot of our work is on the civil side, but we do have a team of criminal prosecutors that work to enforce federal civil rights criminal statutes, one of the major authorities that they enforce is 18 U.S.C. Section 242, or our color of law statute, that prohibits or that allows us to bring criminal charges for law enforcement officers who deprive someone of their constitutional rights under law. And so we've used our 242 authority, for example, to prosecute Derek Chauvin, who was obviously involved in the death of George Floyd, but also we use our 242 authority to prosecute the three other officers who were present on the scene and who stood around and did not intervene. And we argue that that too was a violation of both their duties and a violation of Mr. Floyd's civil rights. We've used our 242 authority to prosecute the office, or to, at this point, to bring an indictment and to prosecute the officers involved in the faulty warrant that led to the death of Breonna Taylor, right? And I think many of us know the story that it was because of that faulty warrant that led to a really tragic series of events that led to Miss Taylor's death that morning in March 2 years ago. And so, we think it's critically important that we think about how we use our criminal authorities to hold law enforcement officers accountable when they engage not just in acts that violate the Constitution, that violate federal rights, but also acts that are viewed through the lens of racial justice, of accountability, and how we make sure that that there is some sense of accountability and reckoning when these events occur in our law enforcement systems. The other tools that we use, I'll talk about really quickly on the civil side. One is our authority under 34 U.S.C. Section 12601, which is a mouthful, but it is our statute that allows us to bring pattern or practice investigations against law enforcement agencies when they, again, are engaged in systemic violations of constitutional or federal statutory rights. And so most recently, we've used that authority to announce our findings against the Louisville Metropolitan Police Department, which was involved in the death of Ms. Taylor, but we also saw that there was a broader exercise of excessive force, of abuse of power, of racial targeting against Black and brown individuals in that community. And we have similar investigations open against the Minneapolis Police Department, the Phoenix Police Department, the Louisiana State Police, just to name a few. And then the last two things authorities that we have are, our authorities under Title VII of the Civil Rights Act, which is an employment discrimination statute, but we share enforcement of Title VII with our colleagues at the Equal Employment Opportunity Commission, though at the Department of Justice, we have authority over employment discrimination by public actors, so by local and state governments. And so we think increasingly it's important to make sure that when there is employment discrimination happening in our criminal justice system, that we hold those agencies accountable. And while we know that having representative policing doesn't solve these problems, I think we tragically know that, we do know that that is a really critical piece of this. And so, for example, we currently have an investigation into the Maryland State Police Department looking at the ways in which we allege that they have discriminated both at the entry-level stage and the promotional stage for Black state troopers. And then the last statute authority that we've been using to kind of address these issues of racial justice in the criminal justice system is Title VI of the Civil Rights Act of 1964, which prohibits recipients of federal funding from engaging in discrimination on the basis of race, color, or national origin. And each year at DOJ alone, we give approximately $5 billion to various actors in the criminal justice system, police, courts, corrections, juvenile justice institutions. And we think that there's more work that we could do to make sure that the dollars that we are giving to those agencies are not being used to further perpetrate discrimination, particularly racial discrimination. And so we're also working to think about how we better use that authority to address these concerns.
So, Anjelica, can I add something? Because I suspect that highly impacted communities would also view racial justice sort of differently than just sort of the obvious, big picture, like police corruption, exonerations. I think they would look at cases where, like last year or the year before, I think a video went viral of somebody going into, I think a Walgreens and shoplifting. And that became a viral video. And at the same time, people are concerned about that, but nobody seems to be concerned that Walgreens did a $4.5 million settlement for wage theft. It's this disconnect between, who's really getting the brunt of the attention and who's getting a pass. And I think for a lot of people, that's racial justice. That's a racial justice issue as well.
Pretty much framing the issue of who is the victim for these racial injustices. That's an excellent point. And as Johnathan, you were sharing about all of the tools that the federal prosecutors have, which is a vast array of tools to try to get at racial justice within these intersecting systems. Professor Capers, if I could highlight your article against prosecutors, which I'm a huge fan of. It was in the Cornell Law Review, and you talk really a lot about the line prosecutors. And I know, Johnathan, we were talking about federal prosecutors, and we have so many prosecutors across the nation who are at the state level. And in your article against prosecutors, you highlight how, and I think Deb talked about this at the last panel, prosecutors hold all the cards, and you're talking about how they sometimes operate as police, the prosecutor themselves, magistrate, grand juries, and other actors within the system on one hand, and then at the other hand, the folks who are going through that system are largely marginalized individuals. Could you share more about that article and your inspiration for it? I know it got a lot of responses from a lot of criminal law scholars, Angela Davis, one of them, Ben Levine. So it'd be great if you could share about that.
So for full disclosure, for the record, I should say I'm a former prosecutor. I was a federal prosecutor for close to a decade. But the article was also largely about maybe it's time we need to rethink prosecution and how much power they wield. So sort of taking some power, or maybe a lot of power, away from prosecutors and giving more power to victims. But part of the point I wanted to make in that article is if we're concerned about over-criminalization, if we're concerned about mass incarceration, if we're concerned about overly punitive sentences, then prosecutors bear a lot of the blame. And I know there's going to be a panel later on plea negotiations, but especially when it comes to things like that, we've just given prosecutors so much power that they could ram a plea down almost anybody's throat, and we call it sort of like equal bargaining power when it's anything but equal bargaining power. And none of that is good for justice. One question Anjelica mentioned, because we had a Zoom beforehand, and she was like, is it necessary for prosecutors to surrender some of their power in order to get at racial justice? For me, it's necessary for them to surrender some of their power to get at justice, period. There's no way to have true justice in this country if prosecutors are basically dictating everything. And even, I'm sorry to go on, but even thinking about the last panel, which I thought was fascinating, and Deborah was talking about sort of passing a new law in Maryland. But at the end, the prosecutors dictated the terms of what that new law would be that would vest them with the power to decide when to seek an exoneration, whatever, past the 90-day period. So some of that power, if we really care about justice, prosecutors, including, again, I was a former prosecutor, we have too much, and we need to give some of that up.
And Bennett, do you have any examples of what that looks like in other jurisdictions? Maybe not even in this country, but in other places as well.
Well, sort of interesting. I mean, in other articles, victims have a lot more power, for example. I mean, basically, we've created a system in this country where prosecutors have a monopoly on criminal justice. And that's not true in Europe, lots of places. It's sort of interesting, our history in this country. We sort of take prosecutors for granted when, in fact, prosecutors are a fairly recent invention. Originally, victims would bring their own cases. They would go to a justice of the peace. They would argue for an arrest warrant. They would argue the case before the grand jury. They would bring the case, and defendants represented themselves. So part of what I'm arguing is not going back to the past. Obviously, I'm not a fan. Look at me. I don't want to go back to, the pre-1800s or anything. But there is something we could learn from our history and from other systems that have different ways of doing things, ways in which prosecutors don't get sort of monopoly power in saying whether they're going to take a rape allegation seriously or not, or take a claim of police brutality seriously or not, or take any claim seriously or not. I mean, we just give too much power to prosecutors. And the result of that doesn't just harm victims, it harms the rest of us because it takes away our power to decide.
And that just made me think about the prosecutors now who are being run out of their offices for trying to do some of the things that you're referring to. We have some prosecutors who have been trying to engage in this power sharing or movement type lawyering, with using their discretion to not prosecute certain offenses that they believe and that evidence may show contributes to, systemic mass incarceration. What advice do you have for them or for individuals even in this audience who may want to go back to their home jurisdiction, change some things up, but could be concerned about that pushback?
So I'm gonna answer it this way, because I'm gonna go back to the prior panel and something I was thinking about throughout that entire panel, and I'm sure I would have been thinking about yesterday if I'd been here as well. So much of this, like the prior panel was like, what can prosecutors do? What's the problem with what can defenders do? And so much of this is on us. I mean, it's not just, and I don't mean us in this room, I mean us sort of like, sometimes it's not like prosecutors just materialize out of thin air and they're either bad or good. We're electing them. It's not like bad police officers just happen. It's just like, usually they're happening in places where people are like, we need tougher police officers. So much of this is on us. And one of the questions is, how do we get us to change? How do we get us to think differently about what it means to be safe, what it means to be a victim, what it means to exercise control? And that's a much larger project than simply changing prosecutor's office, changing police departments. It's really about changing all of us, the culture.
And as you're talking about this culture, Johnathan, I want to loop you into this conversation because as you were talking about the murder of Michael Brown and the other police-involved killings, it seems as if there is now a huge cultural change toward the prosecution of hate crimes too. And so I know this is one area that the DOJ Civil Rights Division has gone into, especially one initiative, the United Against Hate initiative, where you're working with these prosecutor offices at the local level and other stakeholders surrounding this issue. Could you talk more about that with the prosecution of hate crimes?
Sure, and just to respond to the prior discussion, as someone who works in the Department of Justice, probably going to take a slightly different approach to, the authority of prosecutors than Professor Keepers. But one thing I would say that I think is consistent with a lot of those points is, I think the need for greater transparency around these systems, and I think the need for the public to understand the work, certainly on the federal prosecutorial side, and really for the work of the Department of Justice writ large. One of the critiques I often hear, one of the critiques I have against the department, from my time outside of the department, is that it's often a black box, that we don't know what's happening. We don't know how decisions are being made, what kind of gets there. And, while, there's lots of reasons, to protect the integrity of investigations, to protect the integrity of our, and safety of our lawyers and staff, I think that there's more that we probably can and should do to kind of lower so the mystique or the questions or the kind of black box nature of the work that we're doing, and bring in communities, bring in victims, bring in other impacted stakeholders into some of those processes, those conversations, and just understand the work that they're doing. Because as the professor said, these are not systems that kind of are created kind of on high from some mysterious place. These are systems that are critical to our democratic society and functioning. And for these systems to work effectively, to work well, to have legitimacy, we need to, the public needs to understand them and be able to engage with them as appropriate, and also critique them as appropriate to make them better, to make them more responsive. To your specific question, yes, I think, the kind of prosecution of hate crimes is, I think, a top priority for us in the department, and something that, unfortunately we've seen over the last few years, just a really discouraging and troubling rise of hate crimes and hate violence, across the country. One thing that Attorney General Garland likes to say, when he's talking publicly about our hate crimes work, is that, when the Department of Justice was founded in 1870, one of the primary goals of the department at the time was to protect Black Americans who at the time were being attacked, killed by white supremacists like the Ku Klux Klan and others for exercising their right to vote or other constitutional protections. And I think the sad reality is that 153 or so years later, we see that the threat of extremist violence is far too prevalent and far too real for not just communities of color, but for LGBTQ communities, for religious minority communities, and how we respond to that, and also how we engage with communities about that. Because to the kind of earlier point about transparency and legitimacy, when people are going through a hate crime or something like the tragic situation in Buffalo at the Top Supermarket this weekend will be 1 year since that happened. That doesn't just impact those individual victims, but what we have seen, and what I think all of us know, is that impacts entire communities and entire populations who are fearful of, being targeted next just because of what they look like, who they love, where they come from, what have you. And so we have been thinking about how can we do better, both in terms of our prosecution of hate crimes, which is critically important. We in the Civil Rights Division, we have authority under the Matthew Shepard and James Byrd Hate Crimes Prevention Act. And to your first question about kind of racial justice, we brought a hate crimes prosecution against the 3 men who killed Ahmaud Arbery, who was the black jogger who was killed in Georgia. And one of the reasons why we brought a federal hate crimes prosecution there, even though those individuals had been prosecuted at the state level, was because at the time of our prosecution, the state of Georgia didn't have a state hate crimes law. And we thought it was important not that those men be prosecuted for the murder of Ahmaud Arbery simply, but to be clear that they murdered him, they killed him because he was black. And that needs to be part of the narrative that we're talking about and the accountability that our law enforcement systems are demanding when those types of incidents occur. But separate from the prosecutions we're doing, the United Against Hate initiative you mentioned is something that we're rolling out to all of our 94 U.S. attorney's offices across the country by September of this year. The goal of that initiative is to bring together federal prosecutors, to bring together the FBI, federal, state, local law enforcement, and to bring and communities and impacted victims and other stakeholders to talk about how we can better identify, prevent, and respond to hate crimes, how we can increase hate crimes reporting. One of the biggest challenges we face on the federal level, and I think this is true for state and local law enforcement as well, is that oftentimes victims don't want to report hate crimes to, or crimes more generally, to law enforcement because they don't trust law enforcement. They don't think that their information will be treated seriously, or they will generate the response that's due to them. And so our hope with this initiative is to, at a very local, granular level, begin to build those relationships of trust between at least federal law enforcement and communities, and to really encourage and build those relationships so that when the horrific thing happens, when the Buffalo happens, when the Tree of Life synagogue type shooting happens, that those relationships exist already, that there's trust already between communities and law enforcement, and so that they can rely on those relationships to have an effective response. And ideally, that you could do that work to prevent those types of incidents from happening in the first place.
Thank you so much for that. And yeah, I want to save you.
Yeah, because I just want to follow up, because we talked about how this could be a conversation, and I've my school hosted sort of like a thing for the initiative with the Southern District of New York and the Eastern District of New York, U.S. attorneys both speaking. And one thing we didn't hear enough about during that presentation we did at my school, and I'd like to hear more from you, is about prevention. Because obviously, if you're thinking about the big picture, I'm not sure we could really prosecute our way out of hate crimes. It's not like when you incarcerate somebody, you're reducing the level of hate. So can you talk more about what the Department of Justice is doing to actually sort of reduce hate in the first place? Or is the answer to that simply prosecution?
Well, I think the answer certainly is not just prosecution. I think for any of these problems, whether it's hate crimes, whether it's racial justice in the criminal justice system, like prosecution or federal law enforcement involvement is not the solution. I think, obviously with the issue of hate crimes is particularly pernicious and hard to tackle, both because, there are First Amendment concerns and protections, right? And, one of the issues we often struggle with is, we hear, there are really horrific, terrible things that, I personally find objectionable and troubling, but may not rise to either criminal or even civil response. And so how do we, both respect the First Amendment, but also have a response to that? I know we've been working a lot with our colleagues in the Department of Education to think about, how do we begin to engage with students and young people and think about how to address kind of this culture of hate and discrimination and bigotry that we've we're seeing. And again, there are similar First Amendment concerns. There's concerns about kind of federal oversight of curriculum and other issues like that. But again, I think we're talking about that. And then I think the other key to that, two other things I'd say. One is, I think really, thinking about how we engage with civil society around this, right? Because we in government by ourselves, I think, cannot address this problem. But there are I think, tools that religious organizations have, that social organizations have, that community organizations have, in ways to engage around these issues and concerns. And part of, I think, what we're hoping to do with efforts like United Against Hate is to kind of bring them into the conversation with us as the federal government, so that we're thinking about how to respond to that. And then the last thing I would say, which is maybe a half answer to your question, is one of the things that we've also really tried to focus on is not just hate crimes, which are acts that kind of rise to a level of criminal prosecution or involvement, but also hate incidents, which are these kind of incidents that may be happening in schools or workplaces or in residents or communities. And what we've seen is, first, that a lot of times these hate incidents are precursors to some of these more tragic and violent hate crimes. And so are there ways to step in and intervene, either using our civil legal authorities, like Title VII, like I mentioned before, or are there ways to step in using non-legal tools? And so, for example, in the Department of Justice, we have something called a Community Relations Service, which is a part of the department that doesn't have any actual legal authority or enforcement authority, but they were created in the civil rights movement as the nation's peacekeepers. And the idea is that they go into areas of conflict or tension and work on conflict resolution, work on building relationships. And so we've been thinking about how can we better deploy our colleagues in the Community Relations Service to be kind of agents of change, or to help spur some of these types of conversations, some of these types of engagements. Think about how you might use other tools like restorative justice to be responsive to some of these concerns, so that we can kind of use the full array of resources that we have at the department, but making clear, to your point, that our criminal and even civil tools are important, but they're not only woefully sufficient, but they don't, I think, go to what you're talking about, which is, how do we kind of engage and intervene and triage some of these concerns, before we need to take any type of legal action or response to that.
I think this conversation is great because it kind of leads us to a word that I haven't heard yet for this symposium, which is abolition. And it's like we still have to engage those individuals who are demanding something like that from the community, and however it may look like. It could look like restorative justice, it could look like movement lawyering. And so Professor Capers, you have this brilliant piece on Afrofuturism, and what does this system look like 20 years from now? And as I see you all talking about, maybe the future is not having a reliance on the criminal legal system in some type of capacity. Could you expand upon?
Yeah, so I'll say I wrote this piece, I don't know what year it came out, I'm going to guess 2019. Yeah. But the piece was titled Afrofuturism, Critical Race Theory, and Policing in the Year 2044. And policing in the year 2044, because 2044 is when this country is slated to tip from being majority white to majority minority. So I thought it'd be interesting to see what 2044 might look like when people of color sort of are the numerical majority in this country, and really sort of in ensuing years when people of color not just have numerical power, but also political, economic, and social capital power to match. And the reason I sort of picked Afrofuturism and critical race theory is not just sort of to like imagine what it could look like if we sort of took a sort of critical approach and an Afrofuturist approach. So it's almost imagining a better world through those lenses. And for me, what was interesting about sort of engaging in sort of that creative project wasn't just looking at policing, but also looking about how society would be different, because there would be different concerns, I think, if people in color were in control. I think even thinking, going back to the discussion about hate crimes and how we deal with that, I would imagine if people of color were in control, people of color might have more concern about Governor DeSantis sort of like banning what students can learn in schools, and don't say gay bills, and all these efforts to ban gender affirming surgery, than sort of somebody calling me the N-word on the street. Like, they might have different priorities and think some things are more important in the grand scheme of things. But also I think they'd have different concerns about wealth distribution, about the provision of housing, healthcare, and all of that would mean a reduction in crime, because so much of the drivers of crime, let's face it, are economic. They're because of economic disparities. But also I wanted to imagine, even in the future, there would still be prosecutors' offices, but obviously they would look very different from what they look like now. Unfortunately, if you go to a lot of prosecutors' offices, they don't look that different from this audience, which is very overwhelmingly white, let's be honest. They don't really reflect the people. The same is true of public defenders, unfortunately. And I think their concerns would be different. Like, they would be much more on board with thinking about, why is this a crime? Why are we criminalizing it? How can we do things to make things better for everyone? So right now, prosecutors, for example, can't, I don't want to speak, sort of like all, and with a broad brush, but, prosecutors, even progressive prosecutors, tend to find it hard to resist taking money from the state and increasing the size of their offices, as opposed to arguing, like, let's give more money to public defenders. Like, just thinking about a shift in how we think about things, I think, would be radical, and that's what I wanted to explore in my article.
And how are some of the ways that we can do that? I was brainstorming this right before our conversation. I was like, could we get at this through like changing the model rules for, professional responsibility? Is that one of the ways? Like, should we have a requirement that prosecutors are thinking of ways of how to not just power share as well, but to not have a reliance on them in the first place, Yeah,
so again, so much of this is sort of like a cultural shift and shifting the way people think. But one thing, maybe it's just me, and as part of this, as Johnathan knows, like you go through a transformation when you leave the front lines of being a prosecutor and become an academic, because it's sort of you get this distance and sort of this critical perspective. But trust me, as a prosecutor, I was a soldier in the war against crime. I was a soldier in the war against drugs, and so only looking backwards, and I'm like, I wish I had spent more time, and I wish prosecutors had spent more time asking, why do we do what we do? What's the end goal? Who benefits? Who does not? And why? Is the end goal to transform the country so it looks better, or is the end goal simply to sort of maintain the balance of power we have now? So just constantly asking those questions for me is a first step. Once you start getting people to ask those questions, then I think a shift is going to happen, especially if we see sort of a demographic shift. And by the way, I don't think of people of color sort of like the magical like saviors, and I don't think people of color need it. Anybody could do it. I just think like that might be the impetus for thinking about things differently.
And then one thing I would say, working for the Department of Justice, I'm going to have a much less exciting answer to all these questions, unfortunately. But one of the things, I think, when Professor Capers was talking, I thought about kind of building up. His last point was that I do think that there's a lot of value, putting aside the question of abolition, which I will leave to smarter and less federally employed people. But what I will say is that, I do think that there is, for all of us and all the work that we do, like we have blinders, right? We see the work of the world through a lens, and the longer you do that work, particularly work that prosecutors and others do, I mean, when you're dealing with sometimes, the worst of what our society sometimes has to offer, I think it can be really challenging to kind of look beyond that and see beyond that. And I do think one thing that maybe is less radical than tearing down the whole system, but maybe is helpful in the system that we have today, is thinking about how do we work to deconstruct some of those blinders and make sure that whether it's federal prosecutors or other prosecutors are understanding the implications and the realities of their decisions and how they play out in communities for victims. I'm thinking just last month it was Second Chance Month, and the Department of Justice, we hosted a program by our Office of the Pardon Attorney where they brought back into the building individuals who had been pardoned or who had received clemency. As some of you may know, under President Obama, there was a big effort to issue clemency to nonviolent drug offenders who had been sentenced to overlong draconian sentences and unnecessary sentences, and having some of those individuals come back into the building and talk about what that grant of clemency or pardon meant to them, and having them come and actually having the U.S. attorneys or the prosecutors, some of who were involved in their original sentencing, come and say, look, we realize that we can do this better, that we have learned things over the course of time about some of the harms and implications of our decisions. And again, I think those types of kind of conversations and discussions happen far too less in our system, but can happen more of that. And I think it's not just important because of the transparency point I made before, the legitimacy point, but I also think it's helpful for all of us to question some of our presuppositions and some of our operating kind of assumptions, and to think about, are there ways that we can do this that are better, that are less just? Can we really think about some of the racial implications implications or other implications of the work that we're doing. And so again, it's not abolishing the system, which, but I do think thinking about how we make our current system work better, how we make sure that it is more responsive to impacted communities is, I think, something that we all can do, or all of us in the system could do today. I think that has its own impacts in making the work that we do better and more equitable.
And if I could add, I have so many thoughts, but, so many things we take for granted. So we sort of almost take for granted that if we're going to prosecute somebody, that the default punishment is incarceration. And we never step back and say, like, well, why incarceration? Like, what do we actually think incarceration is going to do? Like, we might feel better, but it isn't really solving the problem. So just even having that ability to step back can be useful. Years ago, there was a movement to encourage, I think, judges to visit prisons and jails, and that sort of disappeared. But it's probably shocking, like probably how few prosecutors and judges have ever been inside a correctional facility. And even just doing something like that can sort of change their perspective on what's really going on when we incarcerate somebody. I also have to say, just, because I'm at an academic institution now, I often learn a lot when I have international students, because often, like, something will come up in class, and, an international student would, like, just have this perplexed look on their face, and they're like, wait, you arrest somebody for that? Like, they find it shocking. For some of the things we arrest people for, they just find shocking. Like, they'd be like, oh, that would be a fine in our country at most. Like somebody lying which district they live in so they could get their kid in a better school. Like, we consider that theft and incarcerate the person. So just stepping back and thinking about some of the things we do, I think you could sort of like help tremendously.
That's something that I'm struggling with right now too, even in my own research. I think as academics, sometimes we have the plague of writing this long article and then having this very normative solution, like at the end, like this is going to solve all of the problems. And so in my research on looking into policing crimes that contribute to wrongful convictions, so things such as witness intimidation, assault, I'm not sure if anyone's mentioned the word John Burge, but the massive torture within the Chicago Police Department. And is the answer to that prosecuting more police officers? Like, would that change something? And, part of my research finds that could be the only way that they could separate it from the force. When we look at civil service issues, just having an infraction or what happened with Derek Chauvin is not going to preclude someone from having their job. So from the question of what else can prosecution serve, like maybe it's something else, like not just incarceration, maybe it is, having this awareness of this individual who has caused harm from. So is it like symbolic, but is there another type of court that we could do that in that isn't the criminal legal system?
You're looking at me,
yeah,
so I'm gonna since your research is on sort of wrongful convictions, I'm gonna add my 2 cents about how much is probably going on, and not in terms of wrongful convictions, although that's going on, but in terms of thinking back to the last panel, I couldn't help but think repeatedly, and I think Deborah Levy mentioned this. The communities impacted knew what was going on. And I wouldn't be surprised if some of the arrestees were telling their lawyers or trying to tell their lawyers, this is what's going on. And yet it sort of waits until there's sort of a federal prosecution, like usually there's a slip up when somebody's caught on tape stealing something or planting evidence, that all of a sudden there's sort of this investigation, when people know about it all along. And when I say people, I also just don't want to limit that to the impacted communities. The prosecutors, my office kept Brady lists. Every office keeps Brady list. And we would hide and keep that Brady list like so far from the public. And it's like we are sort of almost complicit. This is being taped, but so what? The rule in my office was basically, before you do a suppression hearing, before you go to a trial, call this person in the office, tell them who your law enforcement witnesses are to see if anybody's on the Brady list. So they wouldn't tell us who's on the Brady list. We could just only say, like, these are witnesses, are they on the Brady list? If they were, that simply meant that instead of calling that officer, you call the officer's partner who is also present. So that officer, whatever, FBI, DEA, whatever, still working, we simply didn't call them as witnesses. That sort of suggests that we're all sort of complicit in a system that doesn't work. You speak to public defenders, they know who the bad apples are, and yet the system just continues. And again, it just seems to be because in a way, this is the system we have and we sort of are comfortable with it. Mm-hmm. We're not upset enough about it to do anything. Like we could go tell everybody in the country, I think the figure from the last session was something like 37,000 exonerees when you look at the group level. My guess is a lot of Americans would say, okay, and roll their eyes and, move on. And I don't know how we sort of galvanize people to want change.
Right.
One thing to say, and I think we've been thinking about in the Civil Rights Division, which kind of, I think, speaks to some of this, is, I mentioned we have our pattern and practice investigation authority, and I think we have been thinking about, are there ways that we can use that authority to kind of tackle some of these systemic problems? Like, so, yes, we have our criminal prosecutorial authority, so we could go after kind of bad actors, bad apples, but like that by itself is not, getting at the core, although I do think that there is sometimes and often a really important kind of public, whether you want to call it symbolic or optical value in saying, that there is accountability, particularly for really kind of public incidents that happen where the public is saying, what does justice look like in this? George Floyd is a really good example where people are obviously really paying attention to that particular situation. But, kind of one example I wanted to point to that I think speaks to some of this, maybe kind of speaks to what Professor Capers was talking about is, we recently announced our findings in an investigation against the Orange County District Attorney and the Orange County Sheriff's Department, where we found reasonable cause to believe that they had engaged in a pattern and practice of misconduct that deprived individuals their due process and Sixth Amendment right to counsel. And so what we had found there, we had looked at their activities from 2007 rather to 2016, where we found that the DA and the Sheriff's Department were regularly using custodial informants, or such as cellmates, at the Orange County Jail to obtain incriminating statements from defendants in homicide and gang-related prosecutions that they would then use against those defendants at trial. And we found that oftentimes these jailhouse informants were acting, as essentially agents for law enforcement to elicit this incriminating information, even though they knew that these individuals were represented by counsel, and also that they knew that this information was often unreliable, that many of these kind of informants were kind of, you regularly use people that had questionable credibility, but yet there was a reliance, both by the sheriff's office and by the DA's office, which is not, I think, dissimilar to the types of problems that, or information, or kind of winking with one eye that Professor Capers was talking about. And so not only was that yielding, not only was that undermining the right to the defendants, like the right to counsel, but it was also just introducing faulty evidence into these prosecutions and leading to convictions that likely were not legitimate. And so, the good news is that, the current DA and sheriff, have disavowed these practices, that we're working with them to come up with a consent decree, that will apply going forward. But I do think that those are the types of kind of systematic investigations that we have been doing and are doing in the Civil Rights Division. I think that goes to how do you both address these problems, but also, to my earlier point, I think that there's value in telling the story that these things are happening, letting the public know that, yes, maybe some people already know this all along, but making sure there's broader public awareness and accountability for these kind of injustices in the system and working to remedy them, through the federal authorities that we do have.
I have so much to say based off of what each of you just said, but with Professor Capers, as you're talking about the practice that the policy from the office that you worked at, if I could just highlight an example, we're in the city of Philadelphia. There are massive wrongful convictions being identified all the time here in Philadelphia. one of which involves the exoneree Hassan Bennett, who was, he actually represented himself in his retrial, the fourth one actually. And in that case, I sat through the litigation. He wore his prison uniform the entire time because he said that he did not want the jury to think that he has been somewhere else other than jail these last 10 years. And the detective who was largely involved for his wrongful conviction, the prosecutors did not call as a witness. He had to call him himself and have the judge require him to come into court to testify. And now the district attorney's office is prosecuting that detective now for perjury and related offenses. And so I just wanted to share that real life example from the policy that you talked about, is that this is not just a policy of the past, they're still happening now, even with progressive prosecutors, where you have incredible officers who are not being called. And so I actually did a CLE recently trying to move beyond the Brady Giglio list, because this list just shows who not to call, who not to call. Yeah. But is this an ethical concern, prosecutors shielding their problematic witnesses?
To my mind, it is, and I'm going to give you another story to match your story. So I was a commissioner on the Civilian Complaint Review Board in New York City for several years. And with the advent of surveillance cameras everywhere and body cams everywhere, occasionally we were able to completely verify the allegation of misconduct by a police officer. But I think because the use of cameras is so new, often the police officers would make a statement under oath first, a statement that was completely self-exculpatory. So we would find out, this officer essentially lied to us. We would then report that to IAB, Internal Affairs Bureau, and at one point, sort of the issue came up. It's like, well, is this information going to the Manhattan DA's office? Is it going to the Brooklyn DA's office? These people, since they've lied under oath to the Civilian Complaint Review Board, that seems like that should be something that these prosecutors' offices would want to know so they could add them to their Brady list. And you sort of get this whole impression like, nobody wants to know this. So the names for the longest were just disappearing and nothing would ever happen, which, sort of, again, I think so many of us are complicit in the status quo. So Anjelica, I'm going to say that more and more often when I find myself speaking at events, I find myself quoting Professor Paul Butler, who teaches at Georgetown, who wrote an article in the Georgetown Law Journal called The System is Working Exactly the Way It's Supposed to. And part of his argument is so many of the things that we're talking about today as bugs are in fact features. And I think we need to sort of wrestle with that very real possibility that the system is working in a way that we as a whole, maybe not the people in this room, but we as a whole, are completely comfortable with.
That's an excellent point. And if I can, A.G. Smith, if I can loop you into something that you said recently about consent decrees with not just police departments, but like sheriff offices as well, and looking into the pattern and practice of prosecutor offices. Is how can these agencies who are here today, individuals who are representative of agencies across the country, reach out to DOJ Civil Rights, say, hey, we've identified something? Because I see a lot of cities are now lining up to ask for help. So resources are tight. How can individuals who are here who observe something that could be a pattern of practice receive help?
Sure, a good question. And you could tell any of us, you could tell me, you could tell our colleagues, I think, on a monthly, if not weekly basis, we receive letters or other communications from, folks all across the country about concerns that they have in different agencies seeking pattern or practice investigations. And, one of the things we often say, we obviously look at all of those requests that come in, we consider them, we've opened, I believe, I think just shy of 10 investigations since January 2021. I expect we'll open some more, but these are among the most resource-intensive investigations that we do in the department. particularly for larger agencies. For example, I mentioned our Louisville Police Department investigation that's still ongoing. We just issued our findings, but I believe we have a team of 20 lawyers working on that, with maybe a team of 20 experts. That a lot of that work involves, looking at years of data, and oftentimes, and many of you will know this, like that data isn't often collected in a way that is actually really usable. And so part of what our teams are doing are reconstructing that data to really understand the patterns, to understand what's happening in those agencies. And so, and I want to be clear, again, to something that Professor Caper said before, there are 18,000 law enforcement agencies, which doesn't talk about corrections or courts. We're not going to open 18,000 pattern or practice investigations. We're not going to open 1,000 pattern or practice investigations. That that tool is important and useful, but it's not a panacea, and it's not a solution to these problems. And that's why I kind of opened by talking about the range of tools that we have and thinking about the different interventions that we've been thinking about. So sometimes we think a criminal prosecution makes sense. Sometimes it's a pattern or practice. Sometimes it's using Title VII or employment discrimination or Title VI. We've increasingly been using the Americans with Disabilities Act, the ADA, because we often find, I think Louisville's an example of this as well, that we see, for example, law enforcement agencies kind of coming in with kind of law enforcement responses where, in fact, there are other non-law enforcement responses that may be more suitable and responsive. And we're thinking about how the ADA may be helpful in trying to think about or reorient the narrative around that. And the other thing I would say too is that we're also thinking about how we can empower other actors of the system to be involved here. So increasingly we see state attorneys general offices, either using their authority or seeking a similar authority from their state legislatures to do these types of pattern or practice investigations. For example, there was just a department in New Jersey, I think Patterson Police Department, where the state AG's office there just announced that they're opening an investigation kind of very similar to the type of investigation that we would do in the Civil Rights Division. I think the California AG's office also announced a similar kind of investigation into a department there. So we've actually done trainings with colleagues kind of at the state and local level about kind of how we do this work, encouraging them to think about how they could do this work as well. But again, I think it kind of goes back to the hate crimes discussion that, again, these pattern or practice investigations are the back end solution to, really the, horrific or, unwarranted situations. And the goal here is really to have interventions before you get to this point, right? Before you get to the need of doing of this type of work. And that's, work that is happening not so much in the Civil Rights Division, but in other parts of the department. So, for example, our Office of Justice Programs, which gives out much of the $5 billion I talked about earlier each year, they have been working to think about how to better incentivize data collection and data reporting among law enforcement agencies and other actors that we fund so that they can identify these problems, not because there's horrific death or incident or shooting or killing, but because they're actually just proactively looking at the information they have, seeing troubling trends and making interventions, kind of on the front end. And I think the more we can encourage those types of responses, not only does it make sense just from a resource allocation perspective, but I think it will lead to a more just and fair system because you will have, hopefully, fewer of these kind of terrible incidents, kind of propelling the type of back-end work that we often do in the Civil Rights Division.
I think that's a great caution for folks in the audience to not wait until something, quote unquote, blows up or like some viral incident has occurred within your office or your community to try to seek out help. And Professor Capers, if I could chat more about your center and some of the things that it has the potential to do as relates to, innovations and criminal justice as well.
Yeah. I mean, we need more money so we could do even more. Yeah, I mean, right now, I think what we're hoping for is to get more involved in sort of work that can help prosecutors' offices, help policing, but a lot of that takes money. So if anybody wants to give us $1 million, you could email me or speak to me after. Or even 100,000. Trust me, I mean, we're cheap.
Well, before I get to questions from the audience, I want to bring up one question that we had on our first day. There was a community member who asked a question. I thought it would be perfect for us to tie that in. And the question surrounded incorporating more grassroots organizations and community groups in these new visions of what we're doing in the everyday work, not just with policy reports and symposium and conferences, but like everyday work. If you all could speak on that and how we can achieve that, that'd be great.
Sure. I think that's I think an issue that we often hear a lot in our work too. And I mentioned our pattern and practice work that often leads to these consent decrees. And part of what we've been doing, I think, for the last few years is thinking about how to make sure these decrees and these consent orders are as effective as possible. And I think we've heard critiques from community members saying like it's great that you made these findings. It's great that you have this court kind of monitor in place, but are the reforms actually working? Is our department is the law enforcement police department actually, reforming in a meaningful way? And these decrees often, take years to implement, and sometimes there are concerns, not just from community, but from police departments, from other stakeholders about, kind of, is it working? Is all this process leading to the goal? And I think we have been trying to be self-critical and self-reflective in that process and thinking about, are there reforms, are there remedies, are there changes we can make to make these interventions as effective as possible? And one aspect of that has been, how do we make sure that we get community involvement and engagement in that process, kind of as much as possible? And I talked about earlier how it's hard because a lot of our processes are opaque. And, when we're doing, for Louisville, our team spent over a year kind of poring over data and, interviewing law enforcement officials and community members, and that, is its own investigatory process. So there may be less opportunity for kind of back and forth engagement in that process. But, last month we kind of issued our findings in that matter. And actually this week, our team is in Louisville holding a series of community meetings all across the city and being really intentional about both where they're going in the city, but also being really intentional about when they're going, right? So one of the critiques we often hear is that, if you hold a community meeting at 2 p.m. or at this time, like that's not going to be workable for many people who have jobs or who have childcare responsibilities or who have other issues. And so making sure that we're not just showing up and hearing and making ourselves available, but also doing so in a way and a manner and time that actually is accessible, that works, that's responsive. And, we just got a report out from our team in Louisville, and, they're having these meetings, and, and people are coming and people are saying, these are the types of reforms and changes and concerns that we have about the police department. And as we are working, in that matter, the city has agreed to work with us to come up with a kind of a consent decree. But before we come up with even a proposal for what that looks like, we are having these meetings. So we're not just looking at the findings based on the data, based on our interviews, but we are also incorporating the voices of communities and impacted individuals and, other groups. And I think also making sure that we're not just talking to like the typical groups, right, that we hear from. I think all of us in government have like our like safe list of groups that we know will like say things that we know that they're going to say and will make us not too uncomfortable. But I think part of this is also making sure that we're hearing from groups that are not on that list of organizations, that we're hearing from the full range of community perspectives, and that we can factor all of those kind of inputs into the types of remedies and reforms that we're crafting. And then I think it's also critically important, even after, we come out with the consent decree or we come out with the settlement, that we also, I think, are open to change along the way, and that we are allowing ourselves to hear from community and other impacted groups kind of in a more iterative and ongoing process so that we can continue to engage in that process and continue to recognize that a lot of the things that we develop in DC that look really good on paper just may not actually translate in communities the way that we think that they should or will. And we need to be, I think, receptive to hearing that in terms of the work that we're doing as well.
That's amazing. That's great. Professor Capers?
Yeah, I agree wholeheartedly with what Johnathan said. And sometimes it's just a question of degree. So one thing I don't think we see enough of, like I'm a big fan of sort of bottoms up, sort of like thinking about things and being open to a bottoms up perspective. So one thing I certainly don't see enough of in other areas is people really going to sort of communities and not just sort of like saying like, oh, we want to hear what you have to say so we can decide, but also going to the communities and sort of saying like, we're actually working for you. Like, how can we help you? And that's sort of sometimes asking questions that maybe are different from what you originally have in mind. So it might be questions, not just like, oh, what should we do about the police in this area, but how can we actually make things better for in your community? Like, what would actually help reduce crime, for example, in your community? What would actually help you feel safer? What matters to you? I mean, so often what we sort of see is sort of a top-down approach, and often with prosecutors and police officers, almost a top-down approach to like, well, this is what we're going to focus on. So you could imagine a community where it's like, okay, well, we notice that you're stopping everybody on the street for stop and frisk, but meanwhile we have this domestic violence going on that nobody seems to care about. Or we have these other issues going on that nobody seems to care about. And we have an unemployment problem that nobody cares about. So sort of like partnering with actual communities and sort of like being humble about who we're actually working for, I think it should be part of the goal.
And the other thing I would say quickly, too, is I also think it's really important as leaders of offices or agencies or, you know, anywhere you are in the hierarchy to model that behavior, because I think so often, you know, I think community engagement could be seen as like, oh, that's something nice to do if you have time. But like, I'm a lawyer, and what I'm really supposed to do is prosecute this case or do this investigation. I think part of what the message we need to send is that no, like part of doing your job effectively is having these types of conversations, these types of engagements. And I think it's critically important, like from top down, that not just be said, but that be modeled for people to see that that's important, that there's value, that whether it's the U.S. attorney or the head prosecutor or the district attorney on down to say, or the federal defender to say, like, I want to make sure that I am engaging with and hearing from the people that I'm actually here to serve, and that their voices and perspectives matter, and that we do our job better when we have that engagement. I think, it's not only important because it's important to do the engagement, but it sends the message kind of down the ranks that, like, yes, like you have to do that as well, and don't expect that you will be viewed as proficient in your job if you're not making that a priority in the work that you're doing each and every day.
That's fantastic. Thank you both so much. We actually have a lot of questions from the audience that I want to make sure we have time to address. One of them is on a subject matter that we weren't able to cover a lot of, so I really appreciate this question. Since a high number of people in the criminal legal system have mental or brain injuries or emotional illnesses that are untreated or inadequately treated, how can we move these cases and individuals who have these disabilities to mental health court and secure treatment beyond, drugging and beyond just their relationship with the criminal legal system? Thank you for the question.
So I'll take the first stab. And for me, this partially goes back to the power that prosecutors have. One way to wield that power is to wield it for sort of just making communities better, making cities better. And one way to do that is actually, agitating for more mental health treatment. I mean, I think prosecutors tend to think, okay, what can we do? We're prosecutors. Well, you could do something that doesn't involve prosecution. You could argue for something that doesn't involve prosecution. And I'm not sure enough of that is going on. And I'll just add a couple of things that really were eye-opening to me because I was completely oblivious. we've talked a lot about race on this panel, obviously, and there's been talk about, George Floyd. One thing I was completely unaware of until a scholar, Jamelia Morgan, brought it to my attention is when we look at the victims of police violence in this country, it's not just a race story, it's a mental health story. The number of people suffering from either physical disabilities or mental disabilities who've been the victims of excessive force is staggering, and it's almost like we're not doing enough about it. I mean, we still have this attitude that, for physical disabilities in general, we want to make accommodations. For mental disabilities, we just don't know what to do. Mm-hmm. And we want to look away instead of finding ways to help those individuals be a part of society. Instead, we just want to banish them. So, prosecutors can try to play some role in shifting that perspective, I think.
And I know you have a lot of questions, so I'll just be really quick. I mentioned the work that we're doing under the ADA, but I would commend, particularly the asker of that question, to go look at our Louisville findings report, which is available publicly on our website. But there's a section that talks about the ways in which the Louisville Metropolitan Police Department is responding to some of these kind of mental health crises. And again, I suspect as we work towards a consent decree there, part of the remedies we will be crafting is ways in which to shift some of those responses away from law enforcement responses to other, social service responses. I think we are seeing some of those conversations happening across the country, but we've actually done a number of filings, either, like I mentioned, Louisville, but we've also filed a number of statements of interest or amicus briefs in cases around the country, most recently, I think, in a Maryland case, where we are, I think, arguing that a failure to do so, not only implicates the ADA, but also that, as a public policy reason, there's need for law enforcement agencies to rethink their responses. And I will note that, there's actually a fair amount of support from law enforcement in this work, right? They're saying, we're not qualified to deal with these situations either. And so having our officers come in to these situations where they don't have the training, they don't have the tools, is, oftentimes a recipe for disaster. And so it's a place where we've actually seen a lot of synergy between the types of reforms we're encouraging and where I think a lot of the law enforcement community is in terms of their own ability to respond to these types of incidences.
Thank you so much. And the professor that Professor Capers mentioned is the Professor Jamila Morgan, who's at Northwestern, and she actually just launched a center called the Center for Racial and Disability Justice. And she talks a lot about, one of her, she guest lectured a class of mine last semester where she talked about disability and the Fourth Amendment, how a lot of police officers interpret, individuals who may have certain disabilities as, reasonable suspicion for a crime or probable cause for something. So definitely review her work if you're interested. So another question we have is particularly about what we see in courtrooms and the quality of legal representation. And so is the instruction available to community groups to participate in data collection? So this question is really as it relates to community groups and if they have access to the same type of data collection. Like we're talking about harnessing this power, but who holds the key to the data? I guess that's the heart of the question. Thank you for the question.
Well, one thing I would say quickly, I know that and we've had a lot of incoming in the department about this, is efforts not only to have better data collection, but to make those data collections available publicly so that anyone could actually take advantage of them and to use them. And I know that there's a number of organizations that are leading that effort to think about, both how to, do the data collection, but to add greater transparency there. And, again, I think, obviously, I think some of the challenges there is that, there's just not, oftentimes the data is just not there. It's just not collected in a way that anyone can use, right? The agencies, DOJ, the public, but then I think there's also this kind of secondary issue of once you do kind of reform better data collection, who has access to it? And one of the things that I think we've also heard, actually from kind of law enforcement and also from municipalities is that data collection just isn't often valued as like a norm of like, we value like, kind of, aspects of the system, policing or arrest, but we don't actually value how we keep and maintain data. And so some of the challenges that people are facing are just like, you have these systems that are just way too old and way too outdated to actually keep up with the task that they need to do today. And so how do we also do a better job of building and supporting and making sure that when we talk about accountability and when we talk about kind of what reform looks like, that's part of the conversation, that it's not just kind of these back-end problems, but also making sure that there are systems in place on the front end that can allow whoever needs access, right, to use that information. And I do think that's a place where like having communities demand that or talk about that or make that part of the conversation is, I think, incredibly important as well.
Yeah, and I think part of that we also see too is that some folks have a rightful criticism about the mass hoarding of information as well. And so we have individuals who may have, gotten exonerated or had their case dismissed, but now their information is just sitting in a police database somewhere for the next 30 years. So whenever they're stopped by police officers, they could see their, prior history of things like that. So that was a great question. Thank you so much. Professor Capers, this question is for you. You mentioned increased video surveillance as allowing the CRB to hold certain police accountable. Can you speak to whether you have any concerns over increased surveillance of communities as a way to hold government officials accountable?
So you might be asking the wrong person. I'm pretty pro. Part of my Afrofuturism piece was actually about communities harnessing technology to benefit them. So it's sort of pro-technology rather than we should all be terrified of Big Brother. It's more like how can we harness Big Brother to actually benefit people on the ground. So I'm very much in favor of, believe it or not, surveillance, and because I think it can actually benefit everybody. It could help reduce crime, it could help apprehend offenders, and could actually help reduce sort of like police abuses, excessive uses of force, police misconduct. So I think there are all these benefits that we tend to downplay when we overemphasize sort of concerns about privacy.
I think part of
that could be a whole other conversation.
I know that's a whole other panel conversation, but one of it makes me think of, after the killing of Michael Brown, a lot of agencies started investing in body-worn cameras as the way to monitor police behavior. But, rightfully so, we also see the criticism that are these cameras now surveilling the communities that they're, that the officers are going into? Like some agencies may have policies that show that require officers to turn on their camera when they're attending a protest movement. So it's like, are you now monitoring protesters? So that's a great question. Thank you for the question. So another question we have, probably our last question, is what are your thoughts about how mandatory minimums and various sentence enhancements factor into racial justice? Any sentencing scholars here?
I just came from, not just came from the day, but what was it, last week? I was moderating a panel at the 50th anniversary of the sentencing guidelines. It was something we were celebrating in New York. Mandatory minimums problem, mandatory sentencing guidelines a problem. But it's almost like, goes back to this Paul Butler idea, like maybe things are just intractable problems. The sentencing guidelines were in part a response to too much discretion and disparities people saw with discretionary sentences. So we had guidelines in the federal system to actually rein that in, but then you just sort of see the same thing rearing its head in other ways, the mandatory minimums, and even deciding like how we're going to set the guidelines in the first place. So problems, no solutions yet.
It makes me think of some research from my colleague, Sandy Mason, who's a professor here, who wrote a paper, Bias In, Bias Out. And so we're looking for ways to try to take race out of the equation. You actually see more disparities there because you still haven't figured out a way of how to address all the racial injustice that preceded this algorithm or any type of sentencing structure that you're currently trying to create now. So So I want to thank our panelists so much for attending, and thank you, audience members, for the great questions.
Thank you very much for a terrific conversation, really thought-provoking. And I think one of the things that we've heard a couple of times in this symposium is the limitations of the structures of the criminal justice system to really get to the underlying societal, historical, cultural challenges that race represents, and yet the need to use those structures to continue to advance the conversation, to continue to expose those instances that need to be changed. And so I really appreciate the way you've teased out all that subtlety and nuance, and even under the constraints of federal employment.